One, two, three, good morning again for Legal English. And today we're going to review an article from University of Pennsylvania Law Review, Adapting Copyright for Mashup Generation. So this is an international article. So you have a title, you have a resume of the problems, and then you have the outline of the problems, all right? So the way the author develops is to approach introduction to the music mashup. Mashup short, creation of music mashup, type of music mashup, marketing, distribution, and monetization, live performance, DJ production, and collaboration with establishment artists. Second part, we discuss about the legal market and policy device, the copyright backdrop, what is past is follow, the uncertain and distorted music mashup marketplace, bridging the device, the K for remix compulsory license. And here they also provide some broader ramification, bridging fair use, binary device, and some conclusion. So the author developed some introduction and describe what is the problematic of this case happening. Growing out the rap and hip hop just as well as advanced in digital editing tool, music mashup have emerged as a defining genre for post-Napster generation. Yet, the uncertain contour of copyright liability as well as prohibitive transaction costs have pushed this genre underground, stunting its development, limiting remix artists' commercial channel, depriving sample artists of fair compensation, and further alienating netizens and new artists from the copyright system. In the real world of transaction cost, subjective legal standard and market power, no solution to the mashup problems will achieve perfection across all dimensions. The appropriate inquiry is whether an allocation mechanism achieve the best overall resolution of the trade-off among author right, cumulative creativity, freedom of expression, and overall functioning of the copyright system. By adapting the long-standing cover license for the mashup genre, Congress can support a charismatic new genre while affording fair compensation to owners of sample work engaging the next generation and channeling distracted music fan into authorized market. And this article, they describe very clearly what they want to do for this article. Let's see, they want to support the policy for open up copyright for the mashup. The legal market and policy divide. As reflected in the prior section, copyright concerns have played a significant but not particularly constructive role in the emergence and evolution of mashup genres. While the protest over the Grey album catapulted mashup music onto the cultural radars, lingering concern about copyright exposure have continued to limit the full blossoming of the genre. Legal uncertainty has important ramifications for the development of music mashup genres as well as for the larger creative and copyright ecosystem. The current circumstances push the growing community of music mashup artists and fans outside of the copyright system and content market. They also limit the ability of new generation of creators to test their talent and pursue financially sustainable career. This part explores the legal market and policy statement. The copyright background. Subsection 1 traces the general requirement for established copyright infringement, the fair use defense, the online safe harbor, and potential remedies. Subsection 2 explores how these standards have been applied to digital sampling. General framework. United States copyright protects two principal components of music creativity. The musical composition, often referred as to the circle C, based on C symbol for the copyright notice, and the sound recording of musical composition, often referred to the circle P, based on P symbol for notice of copyright in phonograms. Subject various limitations and exceptions such as fair use doctrine and cover license. The Copyright Act grants composer and recording artist exclusive right to reproduce, adapt, and distribute copyrighted work. In addition, it grants composer the exclusive right to publicly perform their work. A Mashup artist infringes the right to reproduce by copying a copyrighted musical, musician, or sound recording. This involves two components: factual copyright resulting in substantial similarity of protection expression. The first component is easily proven where a pre-existing sound recording is sampled. The presence of copyrighted sound recording in a Mashup artist's work will surface. A more difficult question is whether the use of the sample appropriated substantial amount of protected expression. Under the de minimis doctrine, courts will generally exclude very small amount of copying because they cause too little harms to justify provide a remedy. The applicability of this doctrine to digital sampling, however, were cast in doubt in controversial 2005 case. Even if the de minimis doctrine does not apply, court apply a multiple facet test to determine whether the amount of protected expression appropriate could be considered substantial by an ordinary observer. The court must first reject the plaintiff's copyright work to filter out the unprotected element, such as idea or unoriginal expression. It's then determined where defendant work is substantially similar to protected expression, a notorious vague standard. So they will examine many ideas that we mentioned about the fair use doctrine, the purpose and characters of the use, the nature of the work, the amount and substantiability of the portion used in relation to copyrighted work, and the effect of the use upon potential market for or value of the copyrighted work. So very famous for step test in Article 107 of the USC. And also has many methods for the application of copyright to digital sampling. With the advent of digital sampling device in the 1980s, a new breed of musical creator will extensively knowledge of beat, recitable, dexterity, and training in recording technology as opposed to musical instrument emerged. According to Grandmaster Flash, an early influential hip-hop artist and DJ, he wasn't interested in actual making music. Electronic drew him in. Likewise, a published enemy Hunt Sockman provocatively asked, Who said the musicians are only one who make music? And hip hop moved beyond the dance club to commercial recording. Issue the copyright infringement followed. Traditional musicians and recording industry executives were not amused by that view as growth problem. And it was not longer before copyright owner threatened and ultimately pursued copyright infringement lawsuits. In a notable early dispute, which ultimately settled, Jimmy Custer sued Beastie Boy of their record label Def Jam over the use of a small sample, less than 2 seconds, on their breakthrough debut album License to 3. In another early controversy, the 1960 pop crowd Turtle sued De La Soul over its issue of their 1960 hit You Show Me, resulting in what were reported to be a 1.7 million settle. The first litigate sampling could reinforce artists and hip-hop labor worst fear about copyright liability. On his third album, I Need a Haircut, this marquee rap song, Alone Again, sampled Irish pop singer Zippo. Hit recording Alone Again naturally. Sullivan published a suit of copyright infringement, prompting the court to grant marking wish for haircut. It is never a good sign for defendant when the judge begins the opinion by quoting the Ten Commandments. First sentence of Grand Opera Music versus Warner Bros. Record state true, so not still. The court analyzed the copyright infringement did not delve deeper than establish that the plaintiff owner of the copyright in both musical composition and the master recording, and thus this marquee sample recording. The decision neither evaluate whether the sampling constitutes substantially similarity of protected expression, nor consider whether it's qualified for fair use. Instead, the court focused on the fact that the defendant has been denied a license, treating the failure to the clear right as fruit of infringement. The opinion assumes without analysis that license is required for any sampling of the show recording, labeling the defendant behavior callous disregard for the law. Judge Duffy conclude the opinion by ordering an injunction as well as standard measure, referring the matter of the U.S. Attorney for consideration of criminal prosecution. Bismarcky learned his lesson. His next album were in time all sample clear. In 1993, another district court applied the substantial similarity framework to a digital sampling case. In evaluating the defendant's motion for summary judgment, the court rejected the defendant's assertion that a finding of substantial similarity for infringement required similarity for the song in their entirety, such as a lay listener would confuse one work for another. Applying the fragmented literal similarity framework, the court focused on whether the segment in question constituted a substantial portion of plaintiff work, not whether it constituted a substantial portion of defendant work. The court found that the break section, which contained the word "oh, move, free your body," were taken. Second, a distinctive keyboard riff, which functioned as both rhythm and melody, include in the last several minutes a plaintiff song, were onto sample in and incorporated into defendant work. The court denied defendant motion for summary judgment, rejecting the connection that Syria of all move and free your body were too cliche and lacking of express quality to attract copyright protection. A somewhat different hip-hop copyright dispute made its way to the Supreme Court in 1994. In 1989, the rap group Two Light Crew produced a parody of Rose Robinson Plastic or Fatty Woman, featuring a rap style and comical lyric. They contacted AQ Rose Music, the copyright proprietor, and offered compensation attribution. AQ Rose declined the offer. Nonetheless, Two Light Crew released its version, which both sampled the original sound recording, altered some of the lyric, prompting AQ to use. Applied the fair use doctrine, the district court concluded that Two Light Crew version qualified for fair use. The court recognized that the commercial purpose of Two Light Crew version cut against justifiably. However, the parodic nature of the work, the song quickly degenerated into a play on words, substituting predictable lyric of shocking one to show how bland and banal of Robinson's song. The recognition that Two Light Crew had to taken no more than were necessary to conjure up the original in order to parody it. And the unlikeliness that the parody would adversely affect the market for the original pushed the court to its fair use conclusion. On appeal, the Sixth Circuit reversed, emphasized that blatantly commercial purpose of the use and appropriate of the hurt of song prevented a finding that version used were fair. In a wide range of opinion that substantially liberal the fair use doctrine, Justice Souter, writing for unanimous Supreme Court, recognized the transformativeness of the use as a substantial factors in assessing fair use, eliminated any presumption that commercial use established market harm, and thereby widened the berth for fairly. The court also eliminated any interference that seeking permission weighed against fair use. Based on this consideration, the court reversed the Sixth Circuit and remanded the case for further fact-finding with regard to the market effect factors. The case settled without further judicial consideration of the fair use balance. A decade later, the Sixth Circuit squarely addressed digital tempo of show recording, ruling that the Copyright Act bar application of the de minimis doctrine in the classwork, with the implication that even the copyright of single note could constitute copyright infringement. Notwithstanding that the de minimis doctrine as well as other copyright infringement standards have largely evolved through common law development, the court based its ruling on a questionable inference from the statute text. So we can find here again in section 114 in some effect. So if you interested in this article, please read more and find out what would be interest for you. It's actually a very interesting article. And if you have any other question, please contact me so we can have more discussion on this issue. And actually, the case will discuss on some financial problems to the extent of use of a sample in a remix work. So nowadays many people have been cover and try to make a derivative work. It should be very interesting to discuss so far. All right. Thank you. And see you in the next discussion.